Good morning, everybody, and welcome to this book discussion on Constitution and Religions, edited by Professor Susanna Mancini and published by Elgar. As we will discover during this book discussion, this is a very key topic for public law at the global level and concerns exactly the relationship between constitutions and religion. And the book provides for a very large landscape analysis of this relationship in many contexts in the world. Therefore, we have important experts with us today discussing this book from very different perspectives and disciplines: law and anthropology, comparative public law, law and religion. And let me introduce them. We will have Professor Susanna Mancini kicking off our discussion and introducing the book to our participants, Professor Susanna Mancini from the University of Bologna. Then we will have Professor Pierluigi Consorti from the University of Pisa, Professor Marie-Claire Foblets from the Max Planck Institute for Social Anthropology, Professor Marco Ventura from the University of Siena and the Bruno Kessler Foundation, and Professor Giuseppe Martinico from the Scuola Superiore Sant'Anna, Pisa. I am Pasquale Annicchino. I teach at the Central European University, and I'm also a researcher at the Bruno Kessler Foundation. I'm very happy to chair this session today. I just want to tell all the participants that this webinar will be recorded. So if you object to the registration, we ask you to leave the book discussion, or to let us know if you want your intervention to be deleted when the intervention will be posted. Thank you very much for all of you for participating in such a great number today, to share your ideas with us in these 2 hours that we are going to spend together. And without further ado, I'm going to give the floor to Professor Susanna Mancini for her opening statement. Professor Mancini, you have the floor. Thank you very much.
It's really wonderful to see how many people have registered for this event. Thank you so much, all of you, for being here today. And of course, a very special thanks to all of the authors of the handbook who are here with us today. It was really a privilege to work with each of you, and I learned enormously from all of my authors, so it's wonderful to have many of them here with us today. And I am not going to be long because, of course, I really long to listen to what all of you have to say about the handbook. I just will briefly tell you something about the reasons for this book and hopefully launch the conversation. The idea here was that I thought this book, when I was thinking about the architecture of the handbook, I thought about something that could fill a gap in the literature. Of course, in Italy and elsewhere, but specifically, I want to mention this. In Italy, we do have a fantastic tradition of law and religion scholars who take a comparative perspective. But I thought that as a comparative constitutional law scholar, I could somehow situate the reflection concerning religion in a different place, because even the epistemological perspective taken by comparative constitutional law scholars differs from the traditional approach of law and religion scholars, in that we tend to place religious issues into a broader perspective, a perspective that assesses the impact of the state structures, right, on the enjoyment of religious freedom. So taking into account factors like the horizontal separation of powers, the control mechanism of checks and balances, the model of constitutional adjudication, even things that don't come to mind so automatically when thinking about religion, like issues of federalism and devolution, for example. Well, all of those factors profoundly affect the protection of religious freedom. Furthermore, one of my preoccupations was that at the time where the international regime of human rights is increasingly contested, the comparative constitutional law discipline could really provide for a critical analysis of the limits of universalism, something Pasquale was just mentioning before. I must also say that as a comparative constitutional law scholar, the study of religion has helped me, giving me a different perspective on constitutionalism, because the place, so to say, of religion in a constitutional order is a very important indicator of the nature of the Constitution. It contributes to a very high extent to shaping the relationship between national and constitutional identity. What forms of church-state relations, how much religious freedom, if any religious freedom, is required in a constitutional order, are all important markers of the nature of the system. It can tell us a lot about how liberal or illiberal a system is. It can tell us a lot about the fundamental values it adheres to, and it can also tell us a lot about what kind of aspiration a state has in the international community. So because of all this, I am really indebted to all of the authors of the chapters concerning constitutional coexistence in different parts of the world, who have really broadened my perspectives and really, I think, offer a wonderful amount of materials for comparative analysis. The other preoccupation that I had when thinking about the architecture of the book is that religion is increasingly important for the study of global constitutionalism. I definitely agree with Pasquale on the importance of placing religion in the context of global constitutionalism studies. The rise of supranational constitutional organisms, of course, not alone, but together with other phenomena like globalization, deprivatization, mass-scale migration, etc., have really squarely challenged the premises of the Westphalian model of coordinating religion and political boundaries. And there is an irony here, because as a result of such challenges, our post-Westphalian predicament increasingly seems to look like the pre-Westphalian era, which was characterized by many of the issues that we experience today: flux in sovereignty, religious transnationalism, religious conflicts, and actual wars of religion. Westphalia really secularized international relations, right? Because it undermined religion as a mode of legitimacy. And most importantly, Westphalia also provided a liberal, so to say, let's say a liberal solution to religious disagreement, because by devolving the question of controversial rights to subnational governments, Westphalia ensured that different conceptions of the right could prevail in different jurisdictions. And for about 3 centuries, while, of course, many things, including the conceptualization of the sources of sovereignty, have changed, but the premises of the Westphalia system have remained fairly unchallenged. And all of a sudden, since the inception of the new millennium, religion has returned as a very contentious issue, not just domestically, but also internationally. So in the book, many chapters make it clear that the erosion of state sovereignty and the weakening of the territorial dimension of identity have made room for the resurgence of religions as transnational actors. Transnational actors that are rooted in religion have found a very fertile terrain to articulate a transnational identity. This is increasingly perceivable. But this identity is potentially a huge challenge, not just to the international order of territorialized nation states that dates back to the Peace of Westphalia, but it is also a challenge to the very legitimacy of transnational constitutionalism, because as Kata Bakker has, I think, very precisely pointed, it predicates constitution making on what is perceived as a universally applicable religious precept. And I think it's very clear what is going on if one looks at the debate at the UN concerning let's say, the confrontation more than the debate concerning traditional values. This kind of confrontations really testify to the fact that there are very profound divergences transnationally as to the role of religion in international relations, in global constitutionalism as a source of identity. As comparative constitutional law scholars, we are, of course, particularly interested in the internationalization of litigation involving religion. This is just one of the aspects that stems from the increasing presence of a very powerful network of faith-based NGOs. Many of them are right-wing, led by US evangelicals and other right-wing Christian denominations, that has become extremely influential in constitution making and in shaping legislation right around the world. And from a comparative perspective, this is really interesting because we've been used to, to think about the, let's say, about comparative constitutional law very often in terms of a conversation among courts, a dialogue among constitutional courts, where there really is another dialogue going on at a different level. I want to quote what you can find. I actually want to read what you can find on the website of one of the most prominent right-wing Christian NGO that has really made a name for its capacity to litigate cases internationally. This is called Alliance to Defend Freedom. And you can read on their website, we are working to defend religious freedom in key international cases because international cases have the potential to set legal precedents that cross national borders and even impact US law. So there is a lot to reflect concerning these developments. The European Court of Human Rights has really proven to be a particularly successful forum for religious lobbies to intervene in cases regarding sensitive issues like gay marriage, religious freedom, consensus objection, reproductive rights, etc. Pasquale himself has written very extensively concerning these issues. For example, he has shown how the high-profile case of Lauzi v. Italy was reversed to a large extent because of the effort carried on by a coalition of actors that range from the Vatican to Russia to American evangelicals, and how much the experience of American evangelicals in religious litigation has served as a model for their European counterparts. So I don't want to take much more time. I just want to say that I had these ideas in the beginning, but every time I received a chapter of the handbook, of course, I was surprised by how many different dimensions I had not thought about. So it was always, every chapter really broadened my perspective and this is really what made the book, the making of the handbook such an exciting project. I really am very grateful because my ideas got transformed through this process, and I really am very eager to hear your reactions today concerning the book. Of course, I'll be very happy to get back into the conversation, but I am really here to listen to you today. So thank you very much, and thank you again, really, all of you.
Thank you, Professor Mancini. Now I can make the announcement also that we are registering this event. So if you don't want to be registered and then published on the Sant'Anna School YouTube channel, please let us know. We will delete the part of your intervention if you intervene, of course. So after Susanna, we start with the commentators. Our first commentator is Professor Pierluigi Consorti, and I'm happy to give him the floor. Professor Consorti.
Yeah, thank you, Pasquale. Good afternoon. I am very happy that I can stay now with you, Susanna, and all people that is now with us, to say some remarks. And I had the privilege to read this book. Probably not all people that is here has already read the book, but it is a very big book that is more than 400 pages, and it is also a formidable reconstruction effort, which make it an essential tool for any scholars of not only of comparative law or constitutional law, but from my point of view, for law and religion studies. And I think not only for scholars, but for the students and also for practitioners that can understand better how things are were built in different parts of the world. Because this is also a universal glance, and this is an effort that I can say it is very difficult to have this universal glance Also, we speak always about globalization and so forth, mondialization, but it is not so simple because of the diversity that we can meet in the history and also in the different land and territories. So I, first of all, must remark this as an important, I can say, an important milestone of our studies in this subject. I can say also that probably from my point of view, the most interesting thing is what also Susanna told some seconds when she spoke about the place of religion in constitutional studies. And I can say this is probably one first remark that can also sign a difference from the point of view of comparative and constitutional comparative studies and low religion studies. According to the difference that we can notice when you have to do a more theoretical approach than an applicative and practical approach that probably is the approach that we as jurists have. The first part of the book is a very interesting reconstruction of secularism, how it was born, and also how it evolves during the years. And I can say it's very interesting, but probably we can also reflect better if it is real that today we are in a moment of a rebirth of religion. I am not so sure that we are in the revival of religion moment, because I think that there is also a wider part of the atheistic and not only from religion point of view. I see that, in my opinion, there is also something that we can reflect in a deeper way about the origin of secularism. For example, I read that, if I am not wrong now, in the chapter of Rosenfeld, there are two major roots of Western secularism, as we all know, and in the book is not well described the third root, that is another root according to the socialist materialistic think that gave a very specific way of state and religion relations, and I think that is also a root of a way of life religion nowadays. And probably we have also, I think that this is why because we paid attention at the theoretical approach more than the practical one, according to the possibility to understand how this phenomena arise today. In my opinion, we have to better define a difference between raw religion as a secularism perception and raw religion as a religious freedom perception. So I think that there are two different approach, two different point of view that must be better underlined. For example, in the book, I appreciate a lot the chapters or the Constitution and politics of religion. I see now also is with us Professor Ferrari, and he can understand very well what I mean when I say that law and politics according to religion is very intertwined. And this is a fact that is not so simple to study when we have a transnational and universal approach. And because it is there are not only different nuances, but very different declination according with different history, tradition, identities, and it increased a lot if we want to study better the law, legislation, and constitutions that are also fundament of these differences, these diversities. In my opinion, another very important stake of this book is the attention that you give to the different tradition, not Western tradition, to understand how they work in their different parts. No? For example, I appreciate a lot the part related to the Buddhist tradition that is not very normally studied, and is always studied as from the Western side. I speak from the Western side. Is not so very lauded. That probably there are a lot of scholars that don't agree that Buddhist tradition is a religion tradition, and they don't want to put this at the same level of other religions. I think that this is also interesting to understand another part that I can say this is the third step that I can do in these remarks. According to the importance of underlining the freedom of conscience and in a wider sense, also the importance of spirituality. Spirituality that is not the same as religion, but is a way of expression of personal freedom and of personal individual identity, that it's not so simple to define in a law system and in a constitutional law system. But it is very important to understand as a principle that is as well as a root when we speak about the dignity and life. We cannot erase, we cannot forget the spirituality. This is not so simple to define in a legal perspective, but I think that is very important to underline it as an essential part of the humanity. I think that we can see also other interesting things that arise from the reading of the book. According, for example, for the freedom, freedom, there is a critic, there is an echo of the critic of multiculturalism in one of these essays in those chapters. And also according to the Latin American situation about the freedom of women and also of LGBT communities and so forth, that I can say in a traditional perspective, it is not the same as religious freedom, but it is the same as a right to be myself. No? When we want to appreciate our own identity as something that the law must protect. We have this in the contemporary constitutions, but it's not so very good delivered all over the world. I want to say another things about the last part of the book, where we find challenges and controversies. And probably here we say the trouble of the moment that we live. Gender justice, religious consensus objection, the integration of Islam in Europe, blasphemy, freedom of expression, and the role of constitutional rights. There is here two cases, especially two cases, the case of Ireland and the personal laws in India. But in my opinion, this is I can say we can use this part of the book as a schema for our future. We can see what we are going to, which are the next challenges we must face to in the future. And probably these are not, this will not be in a battle of religion, but according to the humanity. So religions are not only as institutions. We in Italy normally are more able than other people to look at the religion as institution because of the Catholic Church is so important in our history. But I can see this is a very special perspective that we can have in our point of view, but it's not the same all over the world. And we need a transnational approach, a wider transnational approach, if we want to understand which is the place, I can say now, not of religion in constitution, but of humanity and also the sides of humanity that we can say this is the spirituality, no? The part that is not only what we do, but and what our efforts can say, not only what we see, but also what we do not see, but we have in our conscience, we have in our heart. The law is normally is able to see what happens, but not to understand why the facts are happening. And we must do this effort to understand also why and to leave this in the law. We can say in Italian we say in a juridical way, in the sistema giuridico, but it's not so simple to translate this, but it's in the law system, no? According not only by the constitutional approach, but I can say in a wider and a legal approach. So thank you, Susanna, to give us the opportunity, to give me the opportunity to do these reflections and to share this with you. There are a lot of questions that I can probably have with you, but now let me thank you again for this opportunity.
Many thanks, Professor Consorti, and thank you also for raising the issue of, we can say, controversies, which are provided for and analyzed in the last part of the book. With also Susanna will be one of the commentators to an event that we are organizing on February 6th with Professor Ventura as well. We're there at the Central European University and the Office of the UN Special Rapporteur, where we will be exactly discussing issues of form and gender, which is one of the hot topics today in transnational conversation. So I think that the ideas that Susanna has offered in the book will be a good starting point also for that event. And now I'm very happy to give the floor to Professor Marie-Claire Foblets. Again, I want to thank her. I know she has a very busy agenda, but she made and squeezed her time in order to be here with us and share her remarks, which I think will be highly relevant, also from taking into consideration the perspective from where she's coming from, which is the perspective of law and anthropology. And so we enrich our interdisciplinary perspective on the content offered by the book. Professor Foblets, you have the floor. Thank you very much for being with us.
Can you hear me? Yeah. Well, I think it's also, like my predecessor, up to me to thank you. And in this case, you, Pasquale, because it's thanks to you that I came across this illuminating publication. I really can't find another term. And this brings me to maybe already apologize that I will probably, what I bring in is more what I take from the book than what I bring in. It is a really, like was mentioned already, this is a book that will really be used. And maybe let you tell you why, and I will use just 5 or 10 minutes to say why. I take one sentence as a kind of guiding line for my 5 minutes here is a sentence I take from the introduction, is how the interplay of secularism and religion has become a central feature of contemporary struggles over identity and citizenship. This is the sentence that I really find a kind of summary of the message of the book. Now, how to proceed with this fantastic invitation? So I said to Pasquale, give me at least some instructions. And he said, well, you know, if you want, you focus on Islam and maybe also on Africa. So I took this as really my mandate, and I will focus on how I read, what I take from the book, thinking of law, Islam, and as Pasquale said, we are a Department of Law and Anthropology, and I will come back to this to the very end. Now, for a good understanding of the relationship between Islam and the constitutional frameworks of countries, and that is based on what you do as well, Susanna, is comparative constitutional research. I personally, a few years ago, I learned a lot, and I often keep drawing on Ran Hirsch's, in political sciences, book, Constitutional Theocracy. Now, it's a kind of counterintuitive analysis, because he argues that this constitutional enshrinement of religion is a kind of strategy, a very rational, and he calls it even a prudent strategy that fulfills, and I quote him, the same restricting function it carries out in constitutional democracies. That's his thesis. No? Namely, it brings theocratic governance under the check, and it assigns to constitutional courts the task of gatekeepers against the threat of radical religion. So in one word, it contains religious law. Now, that's the thesis. And then he gives plenty of examples coming from Egypt, from Iraq, from Morocco. He speaks of what he calls the non-secularist world. The majority of the cases come from countries that identify with Islam. And then the analysis shows through all kinds of cases, rulings, how judges in many cases have been opting under reference to religious law for a liberal interpretation of, and in this case, Islam, navigating between the requirements to ultimately draw on religious references, and at the same time suggesting interpretations that would, at first sight, clash with these references. I was fascinated by these kind of illustrations that come from a non-secularist world and showing how constitutional courts proceed, bound by the reference to religion and nevertheless functioning like a modern constitutional court. Of course, and this brings me to what I really also took from the book, it raises the question of legitimacy. Because when the court, in the view of the public opinion, does not have that legitimacy, the interpretation of Islamic law will not be accepted. And he refers, for example, to the Supreme Court of India, that is perceived as the court of Hindus, when it then dares to interpret religious marriage rules. In the case of Muslim spouses, there was an outcry. This court does not have the legitimacy. So it's really showing this difficult position within which courts are, and that owe a lot in terms of their margin for interpreting depends on how they are perceived, if they are kind of legitimate to interpret Islamic law. And this brings me to a discussion we had in Toronto, and I don't know whether he's among us today, but he's one of the authors of your fantastic book, Susanna, Ronan McCree. He raised the question of the appointment of these judges, because with the repoliticization of religion, was then already his concern. I think it was about 6 or 7 years ago. What will remain was his question of this kind of unique hybrid constellation of, on the one hand, courts that are to handle the references to religion, and then the practices of these courts that are practices of modern constitutional courts. And if I remember well, Ran fully subscribed to the relevance of the question by saying, let's see what future brings. Quit was, I think I reformulated the question of Ronan, quit if the majority of the judges in these countries are often trained in Western law faculties, whether they lose this kind of training in a thinking that is more oriented to what we consider modern constitutionalism. So I just kind of thought back of this discussion when I was reading your introduction, Susanna. But I think not just to Muslim majority countries, this interplay of secularism and religion has become a central feature of contemporary struggles over identity and citizenship. Now, this brings me to my own experience, and that comes closest to the analysis in the book by, in I think of 3 chapters in particular. I already referred to Ronan McCree, chapter 17, the Constitutional Order of the European Union, Christopher McCruden, who really illustrates this booming of litigation regarding religious freedom issues, and then Christian Jopke, who really distinguishes these kind of claims by Muslims that are phrased under the heading of equality or under the heading of exemption claims. Now, it's not surprising, I think, but that the courts are ever more frequently the playground of identity claims by, and in particular, Muslims. For myself, I think that one explanation might be that for the moment, if you think of the demography, and I think you refer in your introduction as well, Susanna, to Muslims are for 1/3 living in countries that are not majority Muslim countries, that in many of these countries, I can only speak for Europe for sure, but I can also guess that it might be the case in countries like North America or Latin America, that their presence is too recent to be already represented in parliaments, to be already represented in all these networks of decision-making processes, and that therefore the courts are the channel to claim. So the kind of what you could call strategic litigation, or the way to raise your voice. And this brings me to one of the sentences that also stay on my mind when you write in your historical analysis that religious diversity can no longer be confined to the private sphere. I think, and this is probably the paradox, it has never been really confined to the private sphere. And that is what an increasing number of minority claims made by Muslims all over Europe before secular courts make clear. Whether religious symbols in the public sphere, and I here think of the wonderful expertise by Silvio Ferrari, whether it concerns paid holidays, whether it concerns state support to faith-based, namely Christian schools, they remind us that this public sphere is not neutral. We have all kinds of historical accommodations with majority religions while keeping the promise of the neutrality. And I think these claims make very clear that we are not consistent here. And then the question is how to proceed. See it as a problem or see it as an opportunity, a good challenge. And I think we're bound to start seeing it as a challenge, something that forces us to rethink the principles. Otherwise, we stay in this paradox and that doesn't work. And then there are different positions. We should radically neutralize the public sphere. We should make everybody feel we belong to these societies with a shared public sphere. It reminds me of the whole discussion in Berlin when the rebuilding of what is now called von Humboldt Zentrum, whether or not restore the building, including the cross, which makes the cross being very visible in the public sphere, whereas it's not a church. It's now a museum and it's a cultural center. Another solution are people saying, well, institutionalize Islam, facilitate the funding of hospitals, the funding of schools. This was the way that the Netherlands have been thinking for a while about as being the solution. They speak of columns, zuilen. You have the Catholic one, you have the socialist one, you have the liberal one, and make of Islam, make sure they benefit from the welfare state on an equal footing. All these are discussions. Others say we have been overprotecting religion, and that is probably also the case. For protecting religion more than other liberties, what you get is a religionization of claims. People will claim under the heading of religion what they would probably only claim under the heading of my identity, my culture. And since we don't protect culture as such, you claim it under religion. This increases the chances of being heard. And I really think you speak of identity claims, and there are more identity claims than religious claims. So what a balancing, very difficult balancing between the principle and the reality produces in different fields of law. We see these kind of anomalies that we will not long live with. I'm not a constitutional lawyer, but I see the effects of this kind of balancing exercise as long as we don't have structural answers. For example, in private international law, these Muslim families coming to Europe and not having exactly done what we expect families to do, to be recognized, to be identified as families. For example, they don't register their marriage. So they lack the protection of state law, but they stay within their religious way of thinking of the marriage. And then they get what you call in private international law a limping situation. They're married in one country and not in the country that they are residing in. And this produces very difficult situations when it comes to a clash. Another kind of illustration I could give is, and we all know them, it's the eclectic criminalization of some practices that we dislike. And the fact they are eclectic makes some communities, and in particular Muslim, feel really bashed. Think of the whole issue about penalizing the burkini on the French beach. It was very difficult to give it some ground, but it was prohibited. It was fined. The same now, and there is this, the whole discussion in Germany about boys' circumcision, which was a practice century old, also in Western countries. As soon as the Muslims claim it as a practice, it seems to become contentious. So Muslims react vividly and say, you're just targeting us. The most recent example I can think of is the ruling of the court in Luxembourg on the 17th of December, 2020 on the ritual slaughtering. I'm coming from a country, Belgium, where we really have now opted for radically animal welfare to the detriment of this ritual slaughtering, and the court sees this as not a problem. So you could even speak of Islamization of Judaism, because these practices were covered under reasonable accommodation. And all of a sudden, since now, this is a hypothesis, but since it is also shared practices by Muslims, it becomes a problem. Now, with prohibition, you get nowhere. And I really think, and I speak really convinced that what you bring, Susanne, in your field is exactly what I feel for other fields of law. There is something that we have to do about this kind of not being understood by an increasing number of people here in the world, that the way that we have been thinking of separation of religion and state authorities and state institutions doesn't work. And so who is the problem? We or they? I mean, we have to really think this through. So your book will really be a great help to students. And I'm an anthropologist, and that's my closing sentence, Pasquale, unless you very much. We are observing this kind of not feeling at ease with secular democracy in anthropology. What anthropologists do is try to understand people's behavior, not condemning, not glorifying, understanding. And what you really understand in anthropology is that many people in the living conditions they are in don't have to gain as much from human rights as we think. For example, emancipation all depends on whether there is a society that really supports emancipation. If that society is not there, a woman will not claim her emancipation. So the cost-benefit analysis for people is very often not in the direction of human rights, but in the direction of the belonging, of the tradition, of the religion. And there is a huge kind of responsibility there. We cannot claim universality if we are not context sensitive. And there maybe anthropology can bring in something. I am so happy, Pasquale, that you involved me in this afternoon. And I hope, Susanne, this reconnects us, because last time we met was in Florence. Now I have your book and I will cherish the book.
Thank you very much, Professor Foblets. I'm very happy. I'm very intrigued by your ability to combine law, anthropology, general reflection on our theory of separation, and also final reflection on the crisis of democracy. So I think that was a kind of contribution that we really needed during this afternoon, and it opens up also the way for our final two intervention. So next one will be from Professor Marco Ventura. So we redraw the balance of law religion scholars here from comparative constitutional law scholars. Then we had the law religion scholars, Then we had the law and anthropology scholar, and now back to law and religion. So, Professor Ventura, you have the floor. Thank you.
Thank you. Thank you very much to Pasquale and Giuseppe as well. We are here thanks to Sant'Anna. I'm very grateful sharing the same region of Tuscany with Pisa. I'm in fact speaking from Siena myself. So thank you very much for this opportunity. And then thanks, very special thanks to Susanna for putting up this wonderful book. And for the authors, I gathered that some of them are with us this afternoon. And so I'm very grateful to Susanna and the other contributors. There's a lot to say, of course. I will limit my 10 minutes to a couple of very fundamental issues which pertain to the structure of the book. One is on legal developments, and the other one pertains to legal developments in the context of developments in humanities and social science. The first one is, well, in both respects, the book seems to me as at the same time a photograph of developments in the last years, even the case to some extent. So it's, for someone who would like to have a picture of achievements, the book works perfectly well. At the same time, I see a virtue in the book in sort of propelling the discussion ahead. So the book works very powerfully in both regards as a picture of achievements so far and as an invitation to move ahead, as a powerful engine for moving on. And as I said, I see this effect, this impact of the book, and this potential of the book in both the legal studies, legal work on the one hand, and law within the family of humanities and the social science on the other. Let me say something as quick as possible on these two sides. The legal side and the law family. There's we all witnessed a growing and increasing interest for exchange between law and religion, for interaction of law and religion in many different aspects. And the book works perfectly well at that level. Now, there's an interesting effect, there's an interesting dimension of this rising importance of the interaction of law and religion, which works somehow in a contradictory way, because we observe an increasing interest for this match, for this conversation, this exchange between law and religion. And at the same time, we also witness some fading away, some challenge, even some crisis of the very definition of the two. We live in an age where both are, each on its side, deeply challenged as per their very definition, as per many different aspects. So and this book works perfectly well in giving this picture and giving a sense of the challenge. Law and religion come together very convincingly in many regards, but at the same time, they also share a deep challenge in the definition of each of them. So law is stronger, but it's also weaker. And religion is stronger and is also weaker in many respects. And again, the book works perfectly well there, I think. Now the two probably come together out of a need to precisely react to the crisis. This may be due to the crisis of consolidated legal patterns, which can affect many different, public and private, national, international, well, whatever. I mean, whatever fundamental distinction you take in each of our systems, you can be sure they're under deep tension. So there's and the same goes for positive law and natural law, human rights, private and public law, whatever aspect you take. Of course, this is also true for partitions, disciplinary partitions. So to scholarly work, each of us, we have our own background, we have our own trajectories. We define ourselves by reference to some network or community of scholars, but well, these have also been under great tensions. Of course, some communities and networks, they might be newer to some extent, so they might feel they're probably stronger because they're newer, but all possible communities and networks of especially legal scholars, and especially working on religion, they for sure they also experience deep questions about methodology and the substance and where they're going. And each discipline can be more or less honest in acknowledging its own limits, and or more or less ambitious in feeling for itself that they have the good picture, they have the broad picture. This could be perfectly true for each of us. Maybe not for the community of people in tax law, although someone could make a joke about that and reverse the stereotype. But otherwise, human rights, international human rights, well, they might have a good claim that they are the ones who get the real fundamental, crucial, impactful picture on religion. And people in family law could claim the same. And people in, socio-legal, they could claim the same. And of course, because the interaction is deeply into law and religion, and because law and religion is so flexible, is so nuanced, and so rich, people in law and religion could play the same. As for the sake of Susanna, of course, people in global constitutionalism, comparative constitutional law, they could also claim they have the broad picture, they have the right picture. Of course, none is right. And I see merits in the book by Susanna precisely in the collection of backgrounds she managed to have on board, in the deep integration of different viewpoints, and this is where we really need to be for the sake of a better conversation tomorrow. We need to recognize the need for in each and every community, each and every network, each and every specialty. At the same time, we need to also acknowledge limits and the need to work together, and this is very fundamental. This is also true, of course, for the definition of religion, for the study of religion across disciplines, across areas, and this brings me to the second point, which is legal studies in the context of the humanities and social science. And I take the passage of the floor from Mary Claire to me as a very beautiful illustration of this. Legal anthropology can be a perfect example of the struggle for law scholars also, make sense in other communities, to learn from other communities, to contribute to other communities, and this is true for everybody. So a very fundamental tension for the law and legal scholars and law in action when it comes to religion is also deeply related to the work on religion of anthropologists, sociologists, philosophers, historians, but more and more new kinds of new categories and new communities. For instance, semiotics, for instance. And of course, this will soon, or psychologists, and so, or people in economics, for instance, economists, and these will soon move beyond the border of humanities and the social science that we have traditionally understood it, and move into data scientists, engineers, and data analysts, and computer scientists. So there, I think that, again, the book makes a great contribution as far as I'm concerned, and well, the biographies of the authors make it clear there's a lot of authors, not the majority, but a strong minority of authors do not have a legal background, and we also learn a lot from them. It's also true that in the more legal chapters, and in the introduction by Susanna itself, there's a lot of references to authors and pieces of work which are not legal in character. So this is also fundamental in terms of work. And when the object is religion, of course, this is all the more needed because, as I mentioned, if there's a struggle with defining the law, and fortunately, because, well, the more we are sensitive to this struggle, the more we, the closer we are to the reality of the law. The same applies to religion as well. There's to my knowledge, in the field of religious studies and humanities and social sciences working on religion, the very definition of religion is under question, basically. So lawyers have their share to contribute, and the challenge in terms of awareness and appropriate knowledge to respond to. My final word will be on the connect or disconnect with the civil society. This is probably, the challenge further as we engage with our knowledge and methodology and scholarly work. We all strongly concerned for our role in society and for the sense that our scholarship can make to people. And again, this would be my final word. I think that this book is very sensitive to this need of scholars to get there, to integrate in society, to take responsibility, to take position, to listen, and again to be an example for what law and religion can contribute in this regard, no matter the approach, no matter the disciplinary take, to be an example of reconciliation and integration and proximity between the scholarship and scholars and the real people in society. Thank you.
Many thanks for this intervention. I mean, for those who know me, you know now how much I devoted many years discussing basic epistemological and methodological issues after this intervention, which are key, of course, to any kind of intellectual enterprise. And I mean, in this wrestling between disciplines which are dealing with religion is for sure key and goes well beyond, of course, a single book, but these are basic, I think, methodological struggles. And I think we have to give it back to our host to close the first circle we have to go back to comparative constitutional law before we give some space to Susanna to react. And then, since I want to stress again that there are some authors among us, and you don't see it, but privately, I'm already receiving some questions for some of the authors which are with us. So I think we will have the time to manage and address some of them. But before that, let's give the floor back to Professor Martinico. Giuseppe, you have the floor.
Thanks indeed, Pasquale. It is really great to be here, and I'm very happy to be part of this fantastic panel. Since my colleagues have already raised many super interesting points, I'm going to limit myself to some general remarks. I really enjoyed the book, and basically I think that it is really welcome in our field. That I'm going to develop 3 points. The first point is methodological in nature, and it is in a way related to what Marco was saying. This book responds to a trend in literature that concerning the shift from constitutional law to constitutional studies. Here I'm referring again to Ranierschle, of course, and to the need to read the constitutional law in context, benefiting from the interaction with other disciplinary fields, of course. I mean, sociology, anthropology, Marie-Claire Foblets already stressed the, let's say, virtues of this cooperation. In Ranierschle's words, a constitutional law has been understood as a predominantly, I'm quoting him, legalistic enterprise that is heavily influenced by the prevalent case law method of instruction. Constitutional studies are instead characterized by a greater openness to social sciences and humanities, and we can identify different reasons for this shift. First of all, the importance that extra judicial factors have in constitutional court decision-making patterns. So this kind of approach emphasizes interdisciplinarity and enhances what scholars call the subversive function of comparative law. Comparative law, in other words, is helpful in order to attack some of the cliches present in legal studies, challenging in this way a purely parochial approach to constitutional law. Point number 2. This approach is particularly helpful and welcome in this area, since religion has a very complex relationship with constitutions. On the one hand, religion can be one of the dividing factors that in a heterogeneous context, but on the other hand, it can be part of a collective imaginary which is employed in the construction of narratives and in the unitary attempt made at providing the political entities with the homogeneity even in highly divisive context. It is no coincidence that many of the contributions in this volume adopt a sort of historical perspective. Diachronic comparison, historical comparison, constitutional history are all fundamental to the critical nature of the comparative exercise. And on this point, I'm gonna say something on some selected chapters. I'm very sorry, but I'm gonna be inevitably, cherry picking. I really liked Biaggi's chapter. In this work, Biaggi looks at the role of religion in constitution-making processes, but these considerations can be extended to other areas as well. And in this sense, this chapter offers a very good case study. Indeed, it confirms that constitutions are, so to say, also risk management devices. Here I'm borrowing a concept developed by Adrian Vermeulen, adapting it, let's say, to a slightly different context. Constitutions are risk management devices in the sense that they seek to minimize risks, especially the political risks, including the outbreak of conflict. As Biaggi says in the final part of his contribution, some constitutional strategies normally used to avoid the explosion of conflicts can be identified. This is probably the most interesting part of the chapter, because I found a lot of insights also for other areas. These strategies, for instance, include the use of ambiguous constitutional norms, the deferral to certain matters to ordinary legislation, or the inclusion of non-justiciable clauses. But apart from these techniques, also fictions are, together with silence, two of the greatest instruments employed by constitutions in order to favor integrations. And constitutions are about integration, as Schmann pointed out in his works. Constitutional silence on some sensitive issues can avoid the emergence of conflicts, as Michael Foley stressed it in his masterpiece about the silence of constitutions. But the real question here is silence sustainable in the long run, since it is a strategy aimed at postponing conflicts? So what happens if conflicts arise? And this scenario involves the role of courts. Indeed, constitutions are not only risk management devices, they are also pluralism management instruments and tools for preserving pluralism, as Andras Chaillot and Renata Huitz recall in their chapter about their role of the Strasbourg court. This is related to the difficulties of the role of judges in this area. We often put too much pressure probably on the shoulders of judges, and this risks affecting their legal reasoning and the quality of their judgment, as the Lao Tzu saga shows. In this sense, the dissenting opinion by Judge Malinverni is very telling of this risk. The hard task of judges is explicable not only because they sometimes are not equipped, perhaps, to deal with these issues, but also because conflicts are often inevitable in this area. And here, the concept of constitutional dilemmas, and constitutional tragedies, elaborated among others by Lorenzo Zuccari in Europe, are very helpful in order to understand, the pains of being a judge, especially in Strasbourg. When creating pressure on courts, we tend to forget that they often decide on the basis of arguments brought by the parties or by the amicus curiae, for instance. And here I can refer to McRaden chapters, of course, and to his works on transnational culture wars, and to the role of transnational actors, lobbies, and NGO in triggering and feeding, these cases and this litigation. Point number 3. Pluralism is at the heart of the concept of constitutionalism. Constitutions that renounce constitutionalism and the preservation of minorities risk becoming mere instruments of government. And here the lesson offered by Hans Kelsen is still topical and relevant. The idea of constitutions as instruments of government only respond to the concept of constitution supported by populists. At this point leads me to the opening chapter by Susanna, in which she also analyzes among other things, the consequences of the politicization of religion and the use of religion by populists. Religion, indeed, can play a crucial role in identity politics, which is together with the politics of immediacy and extreme majoritarianism, one of the pillars of the populist approach to constitutions. Susanna refers to Pompeo and Trump in her chapter. Bolsonaro is another example, but also sovereignists such as Orban and Putin are relevant, of course. Indeed, there are interesting contributions about the Russian and the Indian scenarios as well in this volume. And to understand Orban's view on Christian democracy and on the role of the EU, it is useful to recall the text of a speech he gave in 2019. Now I'm quoting Orban now. Hungary is doing something different. Hungary is creating something different. Liberal democracy was viable up until the point when it departed from its Christian foundations. For as long as it protected personal liberty and property, it had a beneficial effect on humanity. But the content of liberal democracy changed radically when it began to break the bonds that bind people to real life. when it questioned the identity of a person's sex, devalued people's religious identity, and deemed people's national affiliation superfluous. And the truth is that in Europe, over the past 20 or 30 years, this has become the spirit of the age. This was Orban. According to these lines, liberalism would undermine traditional values, in particular Christians one, and the EU would be, part of this plot, according to Orban. In Orban's view, Hungary should preserve its special nature, its identity. And of course, here Hungary is just part of a broader trend and could be traced back to the Russian example, if you want. So concluding, the two questions that I have for Susanna are the following. What can we do to avoid that this politicization of religion can feed populist identity politics? And second question, is there room for a sustainable reading of the politicization of religion in liberal democracies? Here I'm referring to sustainability, which was a key concept in Patrick Glenn's works, of course, in his book about the legal traditions of the world. Thank you very much for your attention.
Many thanks, Professor Martinico, for his intervention, which also introduced another elephant in the room, which was always there, which is a political philosophy in a sense. I mean, we didn't have a political philosopher among the commentators, but I mean, we could easily have a political philosopher because the Orban intervention that you quoted could have been a Putin intervention. But surprisingly enough, and Professor Mancini might remind this picture, we were with Professor Mancini in Tbilisi a few years ago, doing some field work, we can call, and we were a bit shocked to see how Russians and conservative Americans could agree on something. And if you look at the contribution by political philosophers today, especially American political philosophers, and how popular they have begun in certain Eastern European countries. I'm referring here, for instance, to the work by Professor Patrick Deneen and his critique of liberalism, which, by the way, even President Obama recommended as a reading book. But in that book by Deneen, you find analyzed many also of the things that we have discussed today, which then have repercussion in the law and so on. So I think that a discussion on political philosophy is also another kind of way to look at the book that Professor Mancini is presenting with us today. Now, Susanna has advised me to kick off the discussion with also some of the authors which are here, and then maybe she will jump into the discussion. And if you agree, and I will abuse of my power as moderator, I will start with our great Professor Michel Rosenfeld, because I have received a question in the chat for him, which is a question similar to the question which I received from the students at CU when I assigned an article from him to read to the students. I assigned to the students is now very well-known article in the Cardoso Law Review on 2009 on constitutionalism and secularism. Now, since the class is composed by students coming from all over the world, I had very interesting reaction from students coming from the Muslim world to reading the article by Professor Rosenfeld, which are encapsulated a bit in this question which I received by Mohammad Ibrahim, which is today with us in the meeting. Now, Mohammad asks to Professor Rosenfeld, as I understand it, Professor Rosenfeld argues for ideological secularism to respond to religious revival in many countries. May I ask, what does it entail? Does he think that ideological secularism could work in Muslim-majority countries where Muslims generally think that their worldview does not differentiate between the private and the public sphere? If not, what could reformers in the Muslim world should look at if they wanted to advance freedom and equality for everyone, including minority groups and LGBTQI people? Many thanks. So, Professor Rosenfeld, I think you can start from there and guide us through the journey of the next 40 minutes, and Susanna then will jump on the bandwagon. Thank you very much. You have the floor.
Thank you very much for this question. And first of all, let me thank all those that have spoken before me. I learned quite a bit from listening to you. There were all excellent comments. This is a very good question. The very briefly, ideological secularism is. I make a distinction, which the article that you mentioned in 2009 did not elaborate clearly, but I have continued thinking about this and drawn this distinction to try to make a cut between two concepts. One is the idea of institutional secularism, which is a basic idea of Western liberal constitutionalism based on the Enlightenment idea that you can separate religion from the public sphere. And obviously, if you look at different models of constitutional relationship between church and state, it's handled differently in different systems. But the basic idea is to get over the idea of wars of religion. You limit religion to the private sphere, and you give it certain privileges that you don't give other ideological positions. And from a constitutional point of view, you try to keep the peace by running the affairs of state without getting into religious disputes. Now, this is an ideal which is never fully realized, but it's aspired to in the whole notion of having religious pluralism within a modern state where you have many religions that are practiced. Now, one more point, and that is the idea of secularism, and I think I point this out even in the introduction that you mentioned. The idea of secularism is really a Christian idea, and although I'm no expert on Judaism and Islam, my understanding from reading sources that are expert is that both Islam and Judaism do not really have a concept of secularism. So we start with that issue. So having said that, obviously the idea of secularism that I am talking about in terms of, let me just say one more thing because I did not specify, although you brought it up. What is ideological secularism? There are a lot of people, and these people exist also in certain Muslim countries. For instance, I've had discussions with people in Morocco and Tunisia, which have a French influence from the colonial days, where you have actual people who are raised in the Islamic tradition but consider themselves secularists. And so the idea is that ideological secularism is a way of life, as Charles Taylor says, is not based on some transcendent relationship. You can have something bigger than yourself. You want to save the environment. You want to do good for humanity. You want to solve the problems of poverty and inequality, et cetera, but you don't, in your day-to-day life, introduce religion as part of your mission on earth. So this particular ideological view has a place, certainly in all Western democracies, alongside various religions and various religious ideologies. The one part where I'm hesitant in the answer to this excellent question that you transmitted is how do we integrate pluralism, which would include people who adhere to ideological secularism and people of minority religions within a state where the Islamic tradition and culture is prevalent. And so I don't know exactly what the relationship should be, but nonetheless, there is in most Islamic countries, including the Constitution of Iran, a place for other religions. Now, in the Iranian constitution, it's limited to a number of religions, and discrimination is justified against other religions. So the question would be, can it be expanded? Can the society learn to live with pluralism? To what extent? By the way, I think a similar problem exists with respect to Israel, which is to some extent, important extent, based on Jewish law, and notions derived from Jewish law that are not, again, attuned to what I would say that secular tradition that comes from a Christian civilization.
Many thanks, Professor Rosenfeld. And I'm happy also that some of my students are in the meeting, so they got a further step to what we discussed in class, and they got it from the original source. So nothing better than this was possible. Susanna, I want to give you back the floor just to react to these, and also to some of the remarks that were made before, from the methodological one to others, because maybe you have some ideas that you want to share with the floor. So I'm happy to give you back the floor.
Okay, thank you very much, Pasquale. Well, first of all, let me thank you all so much. It's not only extremely flattering, I must say, to listen to all these wonderful things you have to say about this book. Now, of course, the merit of the book is really of my authors, because they are the ones that provided expertise, that provided such a nuanced, different and very nuanced perspectives. As Professor Foblets pointed, it's very important not to be able to understand that there is no single discipline that can really provide an overlook on something like religion within the global, let's say, religion, globalization, all these phenomena we talked about. So yes, it was wonderful to have people from other disciplines that really provided a great plus. I also I agree with Professor Foblets on the limitations of human rights frame to solve the problems of religious coexistence in de facto pluralistic polities. It is absolutely obvious to me that women, minorities, etc., have been accumulating rights without having achieved equality. So obviously there is a problem and a tension there. And I also do agree with Giuseppe on the necessity not to overburden courts, not to expect that courts will be ultimately responsible to fix all the wrongs that politics cannot address. There is something else that Professor Foblets mentioned that really resonated to me very much, namely the increasing distance that our discussions, between our discussions on religious pluralism, on the religious tolerance, on religious freedom, and what is actually going on. The use of religion by populist actors, the use of religion by nationalistic actors. It's also a very interesting phenomenon for me to observe, this tension between nationalism and transnationalism, because Orban is a wonderful example. He speaks about Saint Stephen, he speaks about Hungary, about the Trianon memories, etc. But at the same time, all of his discourses also have clearly a European dimension. When he says we need to build a wall to protect a Christian Europe, because those who want to come in are mainly Muslims. So in order to protect, he says it's already difficult to keep Europe Christian. We need to actually build a physical wall in order to be sure that we protect our roots. And the same is true about all this transnational activism. It's nationalistic. I don't know if you read this article the other day on the New York Times that was highlighting the transnational connections of the global right. Starting from the events at the Capitol in Washington, D.C., the article explores all the different connections between white supremacists around the world, from Russia to the United States to many other countries, Germany, etc. Now, all of this is fascinating to me because there is this, this capacity to put together nationalism, to use religion in order to emphasize the national roots, the need to protect the borders, but at the same time to create all these transnational networks. I really don't have an answer to the question that Giuseppe posed, but there is something that I want to share with you, as Giuseppe actually mentioned Hans Kelsen, and it's a really wonderful, I think, lesson that that is always good. I think we are reminded of that Kelsen. It's a reflection that Kelsen carried on. I think it's while reflecting on the preconditions of democracy, when he argued against the claim of theology, right, that it furnishes a foundation for democracy, which it attempts to verify by showing that there is an essential connection between democracy and the Christian religion. Kelsen always argues that a democratic attitude, this is how he defines it, requires what he says should be a relativistic philosophy of values, by which he means a system that leaves the decision about the social values to be realized to the individual acting in the political reality. And Kelsen says it does not and it cannot take the burden of this grave responsibility, right, off his shoulders. And to the contrary, for Kelsen, the assumption that cognition of absolute truths incites into absolute values where possible is very likely to produce an autocratic attitude. So I don't want to add much to this. It's just that, you know, religious doctrines that use the framework of constitutional rights allocation, the rhetoric of human rights discourse, are very much likely to turn protection of right on its head. And in fact, to assert a religious hegemony that ends up by depriving others of fundamental rights, a return to a pre-modern constitutional state. And I do want to stress that when I speak about religious hegemony, I don't speak about religion in terms of the systems of belief. I speak about a heavily politicized version of religion, the one that we're struggling with right now.
Many thanks for the feedback, which moves our discussion forward. I think I have to bring to everybody the salute of Professor Ferrari and Professor Foblets, which, as I anticipated in the beginning, had to leave for another meeting. But we still have some time, and we have some questions which have been raised. So I'm gonna read a question that came to me through the chat, which I think it's directed to Susanna, but I mean, all the speakers can address it since it's a methodological question. The question comes from India, and it's the following one. The Indian courts, as secular courts, often pass verdicts on religious laws in order for it to be balanced with constitutional morality. This violates the idea of limiting religion to the public sphere, and it results in judges practically becoming priests who interpret religion. In such a case, how do we integrate constitutional morality and religion in the correct manner? Do we have a reaction to this? Which is, I mean, it's a traditional, I remember having intense discussion with Olivier Roy on this topic. To which extent judges are formatting religion? This would be the term that Olivier would use. And this kind of quasi-theological role of judges. Now, of course, in many Western countries, we have the traditional doctrine that judges do not discuss, do not decide on religious theological issues. In other countries, as the example that we have just had is a bit different. I know that we have also experts on India. Professor Ventura has written a book on India. I know that Professor Consorti also has important expertise on India, so I welcome also their reaction on this.
So
I'm not really.
Do you want me to?
I cannot explain anything because I'm not an expert. Not maybe and Susanna.
Yeah.
Well, thank you very much for the question. It's a totally fascinating issue, especially because the Indian version of secularism differs to a great extent to its Western counterparts. Now, I am aware of the fact that all secular systems share some characteristics, but I think that there are two fundamental ways in which Indian secularism differs from Western secularism. First of all, Indian secularism doesn't pursue the idea of separation and neutrality, but what in India is called principled distance between religion and the state, which in the end entitles let's say, entitles the state to robustly intervene in religious matters, as the person who asked the question correctly points out, and particularly this is true in the affairs of the country's majority religion. In the second place, Indian secularism, by striking a balance between, let's say, individual religious rights and the claims of religious communities, it does not entail the absolute confinement of religion in the private sphere. And so this is, to me, particularly fascinating because it resonates with Hinduism's emphasis on religious practices rather than non-religious beliefs. And because, of course, practices have a fundamental collective dimension, their predominance somehow entails the valorization of religious communities. So I think that this is important to understand the implementation and the application of secularism in India. Having said this, of course, this should not obscure the fact that the Hindu right has been using secularism in a ideological way, and fundamentally in a way that has emphasized has conceptualized Hinduism as the only fully compatible religion with a secular frame, which has of course produced a number of important consequences in terms of religious minorities, and specifically Muslims. So we all have heard of the Hindutva cases, etc. All the cases also concerning gender equality, like the Triple Talaq case, the Shabano cases, all the divorce cases, etc. So I don't really have a general answer, but I like to the fundamental question that would require another book. But I do want to stress the fact that the ideological use of secularism is widespread well beyond the West. So what Michel was alluding to before, I think nicely fits in the Indian frame.
Thank you.
Can I add one thing, if I could intervene here,
of course,
which is not on India, but is on the general point that one of the arguments for ideological secularism, and obviously it just again doesn't work perfectly in India by any means, but avoids some of these problems, is that by keeping religion and constitutional issues as separate as possible, constitutional judges do not basically intervene in religious law, but accept things as they are. And I'll use the example of one of the cases we had recently in the United States, where in order to give, it's called the Little Sisters case, where in order to give when the church was a group of nuns was giving social services, when you have a social services organization, you have to give health insurance to pay for health insurance, and that included the use of contraceptives. Now, the government said to the Little Sisters that as long as you fill a form saying that violates your freedom of religion, you will be exempt. And the Little Sisters said, we cannot do that because that would make us partners in sin. Filling the form they could not do. And the courts did not go into does it violate Catholic doctrine to sign the form or not, because the courts had to stay away. Contrast this with decisions, let's say, by the courts dealing with constitutional issues in Israel or Egypt, where the court has to get into these things because in Egypt, Sharia is incorporated to some extent in the constitutional order, and certainly in Israel, rabbinical law is a part of the law of the land. And so this has led to decisions, particularly I'm thinking of decisions of the Supreme Court of Israel, where the court feels that it has to incorporate the religious law and the constitutional principles of equality and freedom and so forth and human dignity, which have led to decisions that have very much upset the ultra-Orthodox, saying that it's a total distortion of Jewish law and an appropriation by a judge who has no competence and is probably not only has no competence, but is prejudiced as a secular human being in interpreting religious law. So this is, I think, a very interesting problem from any point of view in which you have involvement of religion within the Constitution and judges who have to render decisions that affect religious law questions as part of their constitutional duties.
Many thanks, Professor Rosenfeld. I was wondering if Professor Ventura had something to ask on the debate on India.
Yeah, maybe. Well, continuing on my line, I would again take developments in India as yet another example of blurred lines in reality, and including in the legal reality, where we might be tempted to see stark distinctions and divisions for the sake of our intellectual pride to some extent, but also for the sake of our work. Of course, we need abstractions, we need strong ideas, we need to, very often fill our pieces of scholarship with even some clarity, explanation, interpretation. The point is that the picture as it is, it's very blurred. And one great example is that we can construe civil law, state law, law of the land, as opposed to religious laws, including in the adjudication, based on some abstract parameters, whereas then in the reality of the legal making, of the political conversation, of the very trajectories of the communities, including in India, the Muslim communities, and again, depending on where, in which state, in which context, the reality is much more blurred. And of course, I'm not denying that there are some structural factors, and of course, for India, the very specific fact that religious personal laws, which have been transformed into law of the state by means of statutory law, are decided by civil courts and not by religious courts, as it happens in other personal law systems, is a structural factor for, then tensions to follow certain patterns and being somehow forced into certain dynamics. But again, what depends to the Islamic community, I'm thinking of the Triple Talaq initiative. Our friends from India knows very well that there has been a long standing, debate there, including within the Islamic community, which of course is not helped by the top-down pressure from the BJP and the Hindu nationalists, of course, but there's a dynamic within the Muslim community about whether to take action, whether to change the law, and again, what are we talking about there? Because again, this is an example of the blurred line between different conceptions of religion, and there again, what is it religion in the end? What in a certain context and under certain conceptual premises would be seen as just an action or just a precept belonging to the external behavior, in a different context is understood as the inner religion, as the core religion. So this would be, of course, the case with reforming the law for the sake of external action for the Islamic community. Again, the Triple Talaq being a fantastic example. What belongs to the community to change, and in which way, and what is then interfered with by national politics and by the state. And this is a perfect illustration of, again, a dynamic where we need our concepts. I'm not denying that. We need our, our infrastructure, including legal. but we always need to remind ourselves about the complexity of religion on the ground.
Many thanks for this, also for reminding us the perennial question of the definition of religion. I mean, we are, as lawyers, often say, it's very easy for us to define what religion is, because religion is what the court decides religion is. And I remember writing an article in 2017 going into the different decisions of the US Supreme Court and see how the definition of religion evolved over the years. And while I was having a look at the table of content of Susanna's book, also taking into account the third point that Professor Consorti made about secular religion and so on, and looking at the recent development in the US, I was wondering, Susanna, if in the next edition of your book, you will have a chapter on Quanon as a religion. I mean, because in terms of religiosity and the density of religiosity, I think that is a little bit another elephant in the room, the diffusion of secular religions, which also cherry pick from traditional religion. There have been important studies on the relationship of the Quanon movement in the US and conservative evangelicals, and how Quanon theology is cherry picking from conservative evangelicalism and is infiltrating the church thanks to the role of digital devices. I mean, it's a kind of thing which I found fascinating in a sense. And actually, I did a little bit of field work over the last few weeks. Field work meaning that I joined Telegram groups of Quanon members. And I can assure you that the kind of stuff that you see circulating there, it's much more than a religion, frankly. So you find letters from the Paul the Apostle, which are reused and reshaped, and then defined in religion millenarist terms. So maybe in the next edition of this handbook, we will have a chapter on secular religions. And I think that maybe in 20 years, we will really have something like that. I don't know, what do you think, Susanna?
So, Pasquale, first of all, I want to have a whole lunch with you because I want to know much more about this field experience. So, yes, I think this is a great idea. Well, with Michelle, in one of the articles that we wrote together, we referred to a case that was decided by a lower court in the United States, where some fundamentalist Christian parents complained that the school was not adhering to the First Amendment because it preferred one religion over the others, and the religion that the school preferred was secular humanism, because it apparently read to the children a passage by a Pearl book where she describes a tide, a huge tide, and talks about the forces of nature. And according to these parents, there is no such thing as the forces of nature causing tides, but to the contrary, it is always the will of God. So this was proof of the fact that the school preferred the religion of secular humanism. So if we engage in the conversation concerning what is a religion, we need another handbook. And you are right, there is so much going on now with these, this mixing of religious and secular perspectives, etc. From a constitutional law perspective, well, I don't have to explain to you that here in Europe we are definitely much more conservative, because we do require that in order to be considered and protected as a religion, a system of beliefs has certain characteristics. We do no longer, European courts no longer require the belief in God, but we do require some characteristic. But in the United States, there are decisions, there's a lower court decision that entertained the claim of a racist, of a white supremacist that didn't want to share his cell with a person of color on the ground that his religion, which I think he labeled as Odinism, mandated that people do not mix with other races. And he lost the case, but the court did not question the fact that his claim was a religious claim in nature. So yes, this is, I think, one of the most fascinating issues. It's perhaps something that is that really deserves a lot of a lot more attention. And okay, in the next edition, of course, I will ask you to write the chapter, Pasquale.
Thank you. And I think since we have still a few minutes, we have I think I would say a final question from Roshan, which is one of our participants today, which connects to this, because in the end what we are really discussing from constitutional law perspective, law and religion and so on, is really the relationship between modernity and religion, or postmodernity, or call it whatever you want. But she says that the modernist turn in Hinduism and Buddhism and even Islam is one which reduces religion to a set of prescriptive either or demands, is the very consequence of a process of secularization. By this we mean that the retreat of the state from matters of religion enables Hinduism, Buddhism, or Islam, for that matter, to revalue the meaning it conveys in only modernist terms. Any comment on this, internal secularization, in a sense, of religion? I see that Professor Ventura has ideas there.
I spoke already too much, but Olivier Roy, to mention someone who's been very much present in the conversation, has a fantastic chapter on the auto-secularization of Christian churches, especially in the West. So this is not a big surprise. This is true. It's difficult to identify causes and effects, right? What belongs to some, well, probably again, there's no clear line between what changes within a religious community or tradition, and because of which causes, and what changes in the political, the polity or in the state. And again, the challenge is to try to say something meaningful there, because we need to say something meaningful there, but at the same time to keep very, very open to the surprise of real life and of society. And again, this book achieves a very good balance in this regard. There's a lot which is said with clarity in the book, and jalons for understanding things, and at the same time it's open as it should be to invite us to progress in the future.
Many thanks. So now I can say it, since we only have 5 minutes left. We were afraid of possible Zoom bombings because of the high number of people that subscribe to this, but Susanna, it seems that being quite careful, we manage it until the end. So I'm very happy with that. We discussed this also with Giuseppe. So I will then give the final word, Susanna, to you and Giuseppe, probably. First to Giuseppe and then to Susanna to conclude. Giuseppe as a co-organizer on this, and then Susanna, for you to conclude on these 2 hours that we have spent together with the commentators, contributors, and the people that join us in this afternoon. Giuseppe.
Thanks, Pasquale. It is going to be a super quick point in the sense that I have learned a lot. I think that this is a fantastic book, a gem. I'm sure it is going to be, a reference, a reference mark, a point of reference indeed for our studies in the future. I already, look forward to reading the second edition or the follow-up. So, and perhaps, organizing another book launch like this. So thanks indeed. And I look forward to listening to Susanna.
Susanna, you are our cassation court this afternoon. So final word for you.
No, I've spoken enough. Thank you so much. It's been really a wonderful event for me. Thank you, really, from the bottom of my heart. Thank you for organizing this, Pasquale and Giuseppe. Thank you to the commentators. Thank you to all of you who posed questions, intervened, etc. I'm so happy that the book has been well received, and definitely we'll keep working all together and maybe have a second edition, or just find other avenues, because obviously this is such a hot topic and there is so much research to be done. Thank you so much.
Thank you very much for being with us. We will communicate when The Sant'Anna team will have done the editing work, and we will circulate the relevant information. So thank you very much for spending the afternoon with us. Enjoy the evening. Thank you.
Thank you. Bye-bye.
Bye.
Thank you. Bye-bye.